All right, good evening. Welcome everybody to City of Troy Zoning Board of Appeals. This is our June 2024 meeting. So welcome to all of our guests and our applicants and my fellow colleagues. It's good to be in an air-conditioned building on a night like tonight. I want to thank our two alternate members, Ms. Chambers and Mr. Forster, who are here tonight, stepping in for two of our other members who are unable to be here. So appreciate them being here to make out a full board of 7. We have some items to tend to tonight on our agenda. So let's get started. And let's begin with the first item on our agenda, which is the roll call. So Mr. Evans, whenever you're ready, if you could call the roll.
Mr. Fox.
Here.
Ms. Chambers.
Here.
Mr. McCauley.
Here.
Mr. Eisenbacher.
Here.
Mr. Forster.
Here.
Mr. Kenkre.
Here.
Mr. Bossenbrook.
I'm here. Thank you. All right. Moving on now. This is the second item, which is our reading of the statement of procedure. And this is a statement of how we hear the cases that come before us. And reading the statement of procedure will be the gentleman to my immediate left, Mr. Eisenbacher. If you could, when you're ready, read for us our statement of procedure.
Yeah. And I'm having a hard time finding the page. There it is. The Zoning Board of Appeals is a group of 7 of your neighbors appointed by the Troy City Council to decide on requests for variances and other matters that are brought before them. A variance is a relaxation of the literal provisions of the zoning ordinance. Applicants must indicate a hardship or practical difficulty with the land that would warrant the granting of the variance. Procedure. The board will hear the items in the order they appear on the approved agenda. When an item is called, the chairperson will verify that the applicant is present. Then the city administration will summarize the facts of the case. If there is less than a full board, 7 members, present at a meeting, an applicant may request a postponement so his or her request can be heard by a full board. If there is no request for a postponement, the applicant will then be given an opportunity to address the board to explain the justification for the action requested. After the applicant makes their presentation and answers any questions that the board may have, the chairperson will open the public hearing. Any person wishing to speak on the request should raise their hand and when recognized by the chairperson, come up to the podium. The speaker should identify themselves with name and address, indicate their relationship to the property in question, for example, next door neighbor, live behind the property, etc., and state whether they are in favor of or against the variance request and give reasons for their opinion. Comments must be directed through the chairperson. Comments should be kept as brief as possible and closely pertain to the matter under consideration. Only one person will be recognized by the chairperson to speak at one time. At the conclusion of public comments, the chairperson will close the public hearing. Once the public hearing is closed, no other public comment will be taken unless in response to a specific question by a member of the board. The board will then make a motion to approve, deny, or postpone the request. In order for the request to pass, a minimum of 4 votes are needed. If the request is not granted, the applicant has the right to appeal the board's decision to Oakland County Circuit Court.
Okay. Yep. Thank you, Mr. Eisenbacher. And Mr. Evans, just let the record reflect that Mr. Green is here. Thank you for coming, Mr. Green, and thank you, Ms. Chambers, for your 5 minutes of service. We appreciate it.
Apologies for my lateness.
All right. Let's move on to our next item, which we will go to the approval of our meeting from last month, from May 21, 2024. Unless there's any discussion to the minutes as printed in the agenda by members of the board, I will ask for a motion to approve. Motion to approve from Mr. Green. Any second? Mr. Kenkre seconds. Unless there's any further discussion, Mr. Evans, can we have a motion to approve the minutes?
Mr. McCauley.
Yes.
Mr. Bossenbrook.
Yes.
Mr. Eisenbacher.
Yes.
Mr. Kenkre.
Yes.
Mr. Fox.
Yes.
Mr. Forster.
Yes.
Mr. Green.
Yes.
All right, thank you. Minutes have been approved. Now we'll move on to our 4th item, which is approving our agenda for tonight as printed. I think, Mr. Evans, you had some comments on that?
Yeah, thank you, Mr. Chair. So item C, which is 2023 Cecil Drive, he has submitted a plan that complies with the code and is withdrawing his variance request because he no longer needs one. So we don't need to hear that tonight. And item D has submitted a revised site plan that's different than what was published. So we're going to republish this, and a new request will show up tentatively scheduled for July. So item D will not be heard tonight either.
Okay. So we will,
And that's for 219 Webb. I'm sorry, Mr. Chair,
Yep.
for anyone in the audience, item D is 219 Webb. So if you're here for Cecil or Webb, those won't be heard tonight. And we anticipate Webb likely being heard next month, a little differently than what's printed in the agenda. Thank you, Mr. Chair.
all right, thank you for that update, Mr. Evans. So in light of that, I think we will need to amend the agenda. Yeah, Mr. Fox.
Motion to approve the agenda as amended, striking items C and D.
Any second?
Second.
All right, second by Mr. Forrester. Can we vote?
Mr. McCauley,
Yes.
Mr. Fox,
Yes.
Mr. Forster,
Yes.
Mr. Bossenbrook,
Yep.
Mr. Green,
Yes.
Mr. Kenkre,
Yes.
Mr. Eisenbach.
Yes.
All right, motion to approve the agenda as amended has been approved. So we will now move on to our fifth item, which we now have two items to consider tonight. One at 4095, 4115 Crooks, and then secondly at 310 Burtman. So we'll begin with 4095 and 4115 Crooks. An administrative appeal of a decision from the zoning administrator. This is somewhat of a different type of appeal than we typically will hear from our usual dimensional or use variance requests. And our liaison from the city attorney and/or Mr. Evans, I think would graciously kind of tee it up for us, kind of what's before us tonight on this appeal.
Thank you, Mr. Chair. So I'm not going to read the whole listing in the agenda, but you are correct. This is an appeal from the, to reverse the zoning administrator's April 9th finding regarding height of a proposed building. The applicant has submitted a preliminary site plan for a project on Crooks Road, and if I could refer to my slides, this is at the northwest area of Crooks and Waddles. The subject property is outlined in red here. And overlaying the zoning map, subject property zone neighborhood node. Adjacent properties to the north and west are zoned single-family residential. That's everything you see in yellow. Just zooming in closer. This is a page from their application, the Zoning Board of Appeals application, just giving everybody an idea of what they're considering doing, and some elevation drawings. So all the documents you're seeing here are of your agenda packet and are part of the application where the maps were prepared by staff. That's the zoning administrator's decision regarding height. So they are here requesting an appeal to that decision, and where it's at is they applied for a preliminary site plan, and that's goes before the Planning Commission, but because the matter doesn't comply with our height requirements, it hasn't yet been sent to the Planning Commission. So it's in the department, and depending on what determination you make tonight, may determine the course of that if and when it gets to the Planning Commission.
Okay, thank you. Mr. Fox.
As the planning commission liaison, is there an issue where if I vote on this item tonight, I won't be able to vote on it when it goes to the planning commission? I just want to make sure before I get involved.
Technically, you can still vote on this because under the ordinance, you can't vote on a matter that you've already voted on that was before the planning commission. If you voted on this matter already in the planning commission, you could not, but since you have not voted technically.
Well, so my question is, if I vote on it tonight, will I not be able to vote on it later on at the planning commission?
Actually, the rules, I believe, are different for planning commission approval.
Okay.
Yes, so But as a zoning board
Okay.
member, I'm only answering your question as a zoning board member right now.
Sure, okay.
Mr. Green, Mr. Green, did you have a question?
I did not. I was referring to.
Okay.
Mr. Fine.
Thank you.
And if we could, Mr. Chair, because these are not common by the board, Mr. Monsi, would you be willing to make a few comments in regards to procedure tonight for these?
As indicated, 99.9% of the cases you get here are variances, and seldom is there an appeal of an administrative decision, and that's why our office felt the need to provide a memo just to provide some procedural issues. This board does have the authority to hear and decide an appeal of an administrative decision, and the board has the authority to either affirm that decision, modify the decision, or reverse the decision. The decision, as Mr. Evans indicated, that's being appealed is one that was made on April 9th, 2024, by the former city manager acting in his capacity as zoning administrator. And specifically, interpreting the ordinance, he determined that the site plan of the applicant presented at that time did not comply because it was his interpretation that portions of the building shown on that site plan exceeded 30 feet, which is not allowed for buildings that are adjacent to residential property. The applicant is asking specifically that that decision be reversed. And again, as I indicated, this board has the authority to reverse that decision, but it can only do so if it finds that the decision was arbitrary and capricious, or that it was based on a material or an erroneous finding of material fact, or that it was an abuse of discretion, or that the decision was based on an erroneous interpretation of the zoning ordinance. In this particular case, the applicant is claiming number 4, that the April 9th decision was based on an erroneous interpretation of the zoning ordinance. Because it's a different type of procedure, for the most part, this board follows the procedure for variances as indicated by Mr. Eisenbacher with a few exceptions. Initially, the applicant will be given an opportunity to make a presentation to the board, followed by questions to the applicant. But because it involves an appeal of an administrative decision, representatives of the city administration will be allowed to also make a presentation, followed by questions from the board. Thereafter, there will be a public hearing similar to the variance. Members of the public can address this particular issue. But afterwards, both the applicant and city administration should be allowed brief rebuttal or clarification of anything said during the public hearing. And after that point, it goes back to the board for deliberation and decision.
All right.
Any questions?
Any questions? I'm sorry, Mr. Evans? Did you have?
There's no questions, and I should let everybody know that on Monday, the city received from the applicant some elevation renderings and other plans that were different than what was presented in the Board of Appeals packet, and it appears that they may be different than what was the determination that was rendered by the city manager acting as zoning administrator in April of this year. The planning department has not rendered a determination on those revised documents that were received on Monday. When I got back from dinner tonight, I saw that I received an email at 4:22 from the applicant indicating that they had a revised elevation. I briefly perused it. They also asked that a revised presentation be presented. I did not have time to include that in tonight's materials, and the department has not had an opportunity to take a look at what I received at 4:22 today. I just wanted to make the board aware of that.
Okay. Mr. McCauley.
I got a question for Mr. Evans. Since we got this information late, are we just reviewing what they submitted in a time, when the applicant was done in a timely manner? Or is it going to be the new information that we're looking at?
Because this is an appeal, the appeal is actually an appeal of the decision that Mr. Miller made in April. So this board should only review that decision based on what Mr. Miller had before him in April. He didn't have the new information, so my suggestion is that that new material should not be reviewed because Mr. Miller did not have the opportunity to review it, and you are reviewing his decision.
Mr. Green.
Sorry, further to that, just some clarification. If, as the claimant has put forward, their claim is that it's an erroneous interpretation of the facts. Is it of the facts presented, or is it of the facts writ large, and therefore the materials provided late would potentially be of interest due to any changes?
In their application, they're actually claiming erroneous interpretation of the zoning ordinance and zoning law. Although this board does have the authority to reverse a decision if there's an erroneous finding of fact, but at this point, that was not one of their claims.
Understood. Thank you.
Well, thank you, Mr. Motzny, for giving us a little bit of the roadmap. Any other questions for city staff? All right, not seeing any, then we will proceed in the way Mr. Motzny outlined. We will begin with the applicant, who will come forward momentarily to present their case. We will then turn it over to city administration to offer their response. At that point, we will open up the public hearing, and any member of the public who wishes to speak on the matter will have an opportunity to do that. After we close the public hearing, then we will return back to the applicant to offer any rebuttal if they so choose. And then similarly with the city administration, also an opportunity for rebuttal. And in between all of those, members of the board may have questions along the way. I guess I'll just also, I think Mr. Motzny and Mr. Evans preface this, but this is obviously a very narrow question that's before the ZBA. The proposed development as a whole is not before us. The details are not before us. This is a very specific question that is being appealed by the applicants. That's very narrowly what we are called upon to decide tonight. So I would just encourage the parties and any public comment to focus on that particular question to help us make a decision tonight. So with that, unless there's any other comments from the board, I will invite the applicant and or their representative forward. If you want to come to the podium, and if you're able to, if we can get.
I apologize for this. Hello, I'm Cindy Victor. I'm here on behalf of the applicant. I will try to stand. I completely severed my tendon from my kneecap, my knee muscle.
One second, ma'am. Is there a way we could kind of get the mic? Is that kind of, can that reach you?
Hear me if I put it there.
I don't know if that's being able to pick. I don't know if we can maybe lower the podium a bit, or.
Oh, perfect. Thank you.
I just want to make sure that the comments and statements made are picked up by the microphone, because that serves as our record, and it allows all the board members to hear what everybody's saying. So we just want to make sure everybody can speak clearly into the microphone.
Try it now.
Okay, is this good? Perfect.
Sounds good to me.
Thank you, and I appreciate the accommodation. This is my 42nd year of practice, and I'm used to standing in front of boards and literally standing, so this is all sort of new to me, and I can't wait till I can stand up again. Hello, I'm Cindy Rhodes Victor, and I represent the applicant. And it is correct that there is a relatively narrow issue in front of you, and that is the interpretation of what your zoning, or not an interpretation, but a recognition of what your zoning ordinance actually says. From the appeal that we listed, we went into the history of this plan, and again, I'm not commenting on any specific features of the plan or anything, but that this was submitted back in 2023. And a number of times, my client received letters saying it's not the right height, it doesn't meet the height, it doesn't meet the height. The section of 5.063 does state that any building or portion of a building on a parcel abutting a one-family residential zone parcel shall not exceed 2.5 stories, 30 feet in height. So it is the measurement, and it says multiple portions of the buildings as measured from the foundations to the peak of the roof exceed 30 feet in height. That was the rejection. That's not the zoning ordinance, that's the rejection. So let's go through a little bit of the history. We submitted plans. We were told they weren't the right height. We resubmitted plans, and they complied with your zoning ordinance. Your zoning ordinance is very specific as in Article 2. Article 2 is where your zoning ordinance sets forth its definitions. It defines building height very specifically. It says that building height, the term building height shall mean the vertical distance as measured from the established grade to the highest point of the roof for flat roofs, including walls or parapets that extend above the horizontal roof surface, to the deck line of mansard roofs, and to the average height between eaves and ridges for gable, hip, and gambrel roofs. This definition provides how to measure grade for sloping terrains. At no point does it mention the word foundation. So that's the definition, what I read you in its entirety. That's the definition. And then you have pictures in your zoning ordinance of what the roofs actually look like. What's a gable roof? What's a gambrel roof? What's a mansard roof? So you have pictures of what these look like and how they should be measured. The issue here related to what was perceived to be a gable roof, and it was being measured from the peak of the roof to the foundation. But that's not what your zoning ordinance says. Your zoning ordinance says it's from the established grade to the average height between eaves and ridges for gable roofs. And that was not what was applied. As we set forth in the appeal, this went on for several months in 2003 and through 2004. And then in 2004, the planning consultant sent email correspondence to my client that said that the building exceeded 30 feet at the peak of the buildings. But we know from your zoning ordinance that peak of the building is not what you measure for a gable roof. So then we asked for a determination, and my client wrote back and said, no, the zoning ordinance says average height between eaves and ridge for gable, hips, and gambrel roofs. And under that, when you measure it that way, they were all under 30 feet. So my client kept asking for an update, and then on March 26th, they was, excuse me, they said they would talk to your former city manager, who was acting as zoning administrator, for his interpretation. That was the word. When there was nothing heard by April 5th, my client again asked for an update. And on April 9, the city manager, Miller, who was acting as zoning administrator, sent a letter to my clients stating, I serve as the City of Troy zoning administrator. I have reviewed the City Crooks Road Development Westbrook Plan Set application dated February 29, 2024. I have found the development does not comply with Section 5.06.3.c seek, and that's because that's not the correct citation, that any building or portion of a building on a parcel abutting a one-family residentially zoned parcel shall not exceed 2.5 stories, 30 feet in height. And then he states multiple portions of the building as measured from the foundation to the peak of the roof exceed 30 feet in height. There is nothing in your zoning ordinance that supports that statement. The only definition that you have in the entire ordinance as to how you constitute building height is found in your definitions of Article 2. And it says from established grade to the average height between the peak and the eaves. That's the only definition. This isn't a neighborhood node district, but in there, it simply says that it can't be more than 30 feet in height. There's nothing in your neighborhood node section, there's nothing in Section 5 of any part that says we measure height differently in a neighborhood node. We do things differently there. Instead, it simply says 30 feet in height. But how do you determine how to measure that? It doesn't say, Section 5.06 does not say any building or portion of a building that's 30 feet in height to the peak of a roof. It doesn't have any of the language that the zoning administrator put in. There's nothing about measuring from a foundation, and there's nothing about measuring to the peak of a roof exceeding 30 feet in height. And while you may hear the argument, well, the particular governs over the general, that would mean that there would be something different in your neighborhood zoning ordinance that would speak to how you measure height. And frankly, it's just not there. The portion of the slides that the city put together that were part of your that were part of your package that you received tonight. By the way, when I talk about it, this comes from your zoning ordinance, Article 2, and it describes what these different roofs look like. And if you see it from the picture that was shown, we have a gable roof. It's the one in the middle. And it says when a residential building is located on a sloping terrain, the height is measured from the highest grade adjacent to the front of the structure to the average height between eaves and ridge for gable roofs, not peak. That's what it states. Now, in your neighborhood node district, you amended Article 5, and in there, in Article 5.06E3C, it simply says it cannot exceed 30 feet in height. Nothing about how you measure it, nothing about how you deal with it, nothing about that it goes to a peak or foundation. You will not find in your zoning ordinance those words that your zoning administrator wrote down. There's no language in Section 5.06E.3.c that contradict Article 2. Now, it wasn't until we received the packet that my client saw what it was that they were objecting to. Because over and over again, as you saw from all the correspondence that I attached as exhibits to the appeal, which were part of your packet, my client kept being told, no, you're too tall, but without any, and we knew they weren't. We measured it according to your zoning ordinance language, and it was the right height. But we saw that when they pointed out here, it was these ornamental little gables on the top, these little ornamental gables. We believe that when you measure from the established grade at the front of the structure to the midpoint here, that it is under 30 feet, and you don't have anything in front of you that says that it's not. But my client looked at this and said, this is silly. If it's a decorative crown on a gable that's getting everybody all agitated over this, we've been waiting now almost a year to get this building up and going. we'd like to move along on this. This is the first time in all this time that we've heard it's these things that were pointed out, these two things. So they said, we'll take them off. Very simple. And that happened on June 5th. And I heard Mr. Evans indicate that yesterday that it was sent, but it was actually sent on June 5th, and it was included in part of a filing in an unrelated matter at the moment. And I sent it again yesterday because I heard nothing. Because to my mind, my client's offer to take that off kind of might have made this moot, like you heard about item C, where they were going to revise site plans so they didn't need to be here. Taking those off would have made it moot. But it doesn't change that the decision made by the zoning administrator is wrong. There is nothing, if this was a jump shot, or I was asking you to interpret something different, but I don't believe, I didn't see anywhere in your package that you received from the city where they said, Cindy Victor's understanding of the zoning ordinance is crazy. Yes, we define building height and how you measure it, but here's the language where we say it's different in a neighborhood node, and here's how you do it. And I know none of you saw that either, because I have the same packet, supposedly, that you all have. It was the one that was posted. So I know that you don't have that either. But as I said, in a spirit of compromise, twice I've proffered this, that we would just remove this, and we have. And my client actually has a demonstration of it, because the main goal here, my friends, is for this project to get up and running. Every day that this sits, without it even going before Planning Commission, on a pretty unsupported, I think my words here, on a pretty unsupported reason that the building height is incorrectly measured, when it was measured in accordance with the ordinance. And your own city managers, your zoning administrator's language has no zoning ordinance support. That's holding my client up. It's costing tremendous time, energy, and money. And trust me, they just want to be moving on this. So it's not that they said, oh, we're wrong, and now we want to revise it and do something else. What they said is, you're the lawyer, Victor, but we're business people. We'll take off a decorative element that we thought would make the place look nice just to get our plan in front of Planning Commission. But that isn't the issue in front of you. That is true what we've done. And I had hoped that in the 13 days that would have been considered, but we're here on the determination that we are here on. So I'm happy to answer any questions. I'm happy to discuss my client's removal of this portion, if that's of interest to folks, because that's what it would look like now. They're happy to show you that. We have pictures of it, if that makes any difference. To show that they've taken that off, and this is what's in front of the city right now, if that's important. But it doesn't change the obligation, which is that every person who comes before the city, every person who wants to do business in this city, has the right to the same application of the zoning ordinances. It doesn't matter who that person is, or whether somebody likes their project or doesn't like it, or whether, if you can paint a building bright pink in your city, and it's bright pink, but people don't like bright pink, everybody has the right to have the ordinances followed fairly and not arbitrarily against them. And we believe here, based on the language in Article 2, which is the only place you'll find a definition of building height, and the definition or the language in Section 5.06.E.3.C, which simply says 30 feet in height, and the pictures of how you measure a gable roof that are part of Article 2, that we think that the zoning administrator's determination that the building that's being measured from, quote, the foundation to the peak of the roof exceeds 30 feet in height is not supported by the zoning ordinance. And as any member of the community would want the ordinances applied fairly to them, so does my client. They believe they're in compliance with Article 2, and they want that applied to them. That it should be, we're looking for a determination from you that the building should be measured from the established grade to how you measure a gable roof. From, and let me read it exact because I don't want to go by memory, from that the building should be measured from the established grade to the average height between eaves and ridges for gable roof. We believe that's the decision we're looking for from you because that's what Article 2 says. And I'm open to questions.
All right, thank you, Ms. Victor. Is there any member of the board that would like to ask a question for Victor? Mr. Eisenbacher?
I have two questions. In reviewing the packet and looking at all the elevations for the two different, what I believe is two different general styles of buildings, and I know this isn't exactly what the question is the number of stories. We're looking at the number of feet. But it was a little bit confusing because it appears that some of the buildings have 2 complete stories, and then the third story is partially submerged underground. So that's where the 2.5 is. And then another building has 2 stories that are fully above ground, and then the roof area is the half story. Is that correct?
No, the roof area is just purely decorative.
All the different
The
versions?
pointed, right, correct. The pointed little roof that they pointed out, and they're going, this is decorative.
It's always decorative. Okay, so there's no storage or living space in the roof
No.
on any of them? Okay. That helps me understand.
And yes, there was never a question that we didn't have the correct number of stories. It's always been feet, how they measured the feet. And as the zoning administrator said, they're measuring it from foundation to the peak of the gable roof.
Okay. And then my second question is, and it ties in with the last part of your statement about you want the even interpretation of the laws. Did you research any other of the apartment or townhouse projects within the city of Troy, and you found?
They were all measured from the average height. We are the only one that was measured from the peak.
Do you
There
have
were-
specific examples of this?
I do, and I'm trying to do it off the top of my head. I'm not sure that we put it in here. It's something that I know we did present to the city attorney, the other ones. But yes, I did go through a number of, anybody who had a gable roof that was presented to the Planning Commission, and they were all measured. That way, none of them were measured from the peak down. Let me see if I put that in here. I did not put the comparables in there, but I can tell you that there are 10 of them. And I know that if I come back for a rebuttal, the good folks with me will give me those names.
Okay, yes, if you could
I will do
get that ready for what the
I will
rebuttal,
do
I'd
that.
like to see that.
Correct. I will do that.
Mr. McCauley?
Also, going along with that information, when you get that information, I'd like to know how many of those are in neighborhood nodes also.
That, I believe they are, but I don't know that specifically. But thank you for bringing that point out, because there's nothing in your neighborhood node district that says we measure differently in a neighborhood node. And there's nothing anywhere in the zoning ordinance. You have one definition of building height, whether your neighborhood node, residential, commercial, industrial, you have one definition in the zoning ordinance for how height is measured. So it's not district specific. And when you go to your zoning ordinance for neighborhood node, there isn't something that says we measure height differently here.
Yeah, Mr. Kincrey?
I'm sorry.
I'm sorry, can you identify yourself, sir?
My name is Sam Staffa. I live in Troy for over 20 years.
This
And
is
I-
my client.
Yes, and I'm a builder for over 20-some years. I never heard such a thing that we're discussing tonight, how we measure the house, how we measure, what's the definition of a height is. I heard that this is unusual. Absolutely, it's unusual.
Okay, Mr. Kincrey?
In your review of the zoning ordinances, have you seen this phrase, or portion of a building appear anywhere outside of the neighborhood node section?
I'm not sure I understand the question. Are there buildings that are outside neighborhood nodes? I don't know that I understand.
My question is, in the zoning ordinances, that there's a section for neighborhood nodes.
Right.
So does this phrase, or portion of a building, it says any building, comma, or portion of a building, it's kind of like a special phrase that has been put in there, but does that phrase appear anywhere other than the neighborhood node section?
I believe that it does. I think that you do have that language, but whether you do or not, it's any building or portion of a building can exceed 30 feet. So what it means is also that if you're just doing a partial building, it doesn't mean that you change the definition of the roof and how it's measured, because you still have how building height is calculated. And to do that, you have to go to definitions. That could have been written in. Somebody, when they amended, when they created that section, could have said, in this node, in this district, gable roofs will be measured to the peak. Then that would put everybody on notice that gable roofs are measured to the peak. But there's no language like that that says, don't follow Article 2, which we applied for everywhere else. And, to follow up on the other question, other buildings are measured that way. Yeah.
I have a two-part question.
Sure.
So the phrase building height that you're relying on is one of the defined terms in the zoning ordinance that applies wherever that phrase is found.
Correct.
Just like any other defined phrase in the first part of the zoning ordinance, wherever you find it in the zoning anywhere, that's the definition. And then it says otherwise, if a word isn't defined in the definition section, you just use its ordinary understanding.
Correct.
So the phrase building height is not used in 5.06. Let me finish my question. When this ordinance was drafted, it was not drafted to say the building height may not exceed 30 feet. It doesn't say that. So I can understand if this was a clearly defined term, this wouldn't even be here in front of us, because that would be clearly defined by a specific definition in the zoning ordinance, and that's how we would read it. But the drafters of the zoning ordinance didn't put that phrase in there. And I guess one of the rules of, interpreting statutes, laws, zoning ordinances is that we have to take into consideration when some phrases are used and some are not. So I guess my first part of my question is, doesn't that affect your argument if they intentionally, I would say, didn't use the phrase building height in that section?
No, not at all, because also part of an interpretation of an ordinance is to not, and it's the same way with case law too, and statutes and statutory interpretation. We don't parse hairs to make it an illogical meaning. So your statement says any building shall not exceed 30 feet in height. That is building height. So, and you don't have it written otherwise elsewhere. But what tells me it's not that is when I look at your picture, I don't see the word building next to height definition illustration. I just see the word height. And it follows underneath that definition, and it's got the gable roof, and it's got a little picture of how to define it and how to measure it right here. So height definition, and then a picture. So to me, when I see the word 30 feet in height, and I see height definition, and I see a measurement sign here, that's pretty clear to me that that interpretation would control.
Thank you for that explanation. So the second part of my question is, this is kind of building off of what my colleague, Mr. Kenkre, said, is 5.06 uses the phrase or portion of a building. Now, to get to the definition of building height, as you explained well, it's the average height, in the roof area. So you could have a building height that is less than, let's say, the absolute height of the structure, right? I mean, if the average height is lower, I mean, even your measurement says that, in your estimation, the average height is 29, or the building height is 29 feet or slightly, somewhere in there.
Correct?
But clearly, it's taller than 29 feet. So I guess what I'm hung up on is the zoning ordinance also intentionally included the phrase "or portion of a building." So it seems to suggest, and you can respond, and I'd like to hear, a response, but it seems to suggest not only is it saying the building height can't be more than 30 feet, but any portion of the building can't be taller than 30 feet. So that even if you have even if the average puts you here, but you have a portion of the building taller than that, then you have a portion of the building that's taller than 30 feet. Isn't that what the zoning ordinance is getting at?
No, I don't believe so, because if you have a portion of a building, again, why would you have a definition of how to measure different types of roofs? A portion of a building, so it would be this portion can't be higher than 30 feet, this portion can't be taller than 30 feet. It's to say that portion of the building means it altogether. Ignore the definition, ignore the pictures, ignore the graphic on how to measure it, because we're going to say it's a portion of a building that's taller. No, I think what it means to say is that you have buildings that are different sizes. You have buildings that are, some buildings that are 1 story, and some buildings that are 2 story, and some buildings that are 2.5 stories, and any portion of that can't exceed 30 feet in height. That's what that means. That's what's been interpreted before in other jurisdictions, that's what that tends to mean. So I don't see it that way. I don't think there is any support for it. And again, you have a history of interpreting it in a way that follows what your zoning ordinance says in the average between the eaves. Why it's not applied to this particular building and why it says foundation, there's nothing there that says foundation. To peak of roof, there's nothing there that says peak of roof. So no, I don't think that's the case. I think portion of the building means I couldn't come in with a building and say, I'm relying on my 1-story building. You would point to it and say, but a portion of your building is 2.5 stories and it's 30 feet. That's what I believe that says.
All right, thank you. Any other questions? Mr. Fox?
Do you happen to know off the top of your head what the height from the grade to the peak is?
I do not, but I know that the height, I know it's just barely, if anything, 30.
Okay.
Yeah. And I know doing the average measurement, it's under 30, as we've set forth in the pictures that were attached.
Okay. Thank you.
Mr. Kinkery?
I'm going to try a different way to kind of express myself. So the word building height, I think, means that a building may have different physically measured heights at different points on the roof. But for the purpose of planning, somehow they all have to be aggregated and turned into a building height. And that's why you take the averages and all of that. And all of that applies to the whole building, recognizing that different points on the roof may have different physically measured height from the grade. So that's why you get a building height. So in that specific portion, which is in the neighborhood node, when they say or portion of the building, I think they're saying that we're kind of getting away from that concept of a building height, which is height for the whole building, but we are really looking at the different pieces, and we are only saying height at the end. The word building height doesn't appear, and so the height really refers to a physical measurement from the grade to the tallest point. So I'm kind of thinking that it could have been written differently, but I think when I take the whole zoning text, where one place they say building height, where they kind of insert this phrase specifically saying or portion of the building. They only use the word height and not the building height, so as not to confuse that with the definition of the building height. So I think what they mean, is exactly how they have interpreted.
Mr. Concrete, not to be disagreeable in any way, but there's absolutely no support for that in your ordinance, because I get what you're saying. You're saying that you think that that is what they intended at the time they wrote it. But we are all bound by what the words say. We can't read in, we can't rewrite it. We can't say, well, this is what we should have it say. It should have been this, and this is the intention. That is not how we interpret what ordinances say. We interpret what they say based on the words that are there. And when we talk about any building or portion of a building, this is the building. These portions right here, the bulk of it, nobody has any question that that's all below 30 feet. That's not even anywhere. So now to your issue of building height is different than height. It doesn't work because your ordinance uses just the word height, and it does it in a picture to make what you said not acceptable, because this picture in Ordinance 2 says that's not the point. It says height, and it says definition, and it says illustration, and it's got the gable roof, and then you see this little graphic of how you measure the height. It doesn't say building height. If the words building height are next to each other, it says height definition. I see the word height, 30 feet in height. I see height definition illustration, and I see how you measure it. So there's no way to say in your ordinance the additional words that y'all want in there. Now, the city has the power to change the ordinance anytime it wants. And if it wants to add in what y'all want it to have in there, it can do that at any time. But given the ordinance as it is written today, there is nothing in any portion of the ordinance that supports a determination that the building should be measured from the foundation, and there's nothing that says that anywhere, to the peak of the roof. Nothing anywhere. So
I certainly see your point, but if I go to the text of definition, where the definition is given, it says, it begins by saying the term building height shall mean. It basically says that we are defining the term building height, and it ends by saying this is the basis for determination of the building height.
correct. And to split hairs to say, well, the word building isn't right by height isn't something that I think would survive any further scrutiny if this was to go beyond. But to make it more clear, that your drafters of your ordinance made sure that you wouldn't split hairs that way by creating your own illustration. This comes from your zoning ordinance. After you have the definition, then in your own ordinance, they gave you a picture of height, definition, illustration, and how to measure it. So they gave you a graphic that we don't even need the written definition for. We have a graphic that tells us what to do with just the word height.
Ms. Victor, can I ask a question about that?
Sure.
So when I look at 2.01, which are the rules of interpretation, let me find the right section.
B,
I'm sorry, what?
I believe it's B.
Right. So my question is about section B. It says, in the case of any differences of meaning or implication between the text of this ordinance and any caption or illustration, the text shall control. Mm-hmm. So I understand the point you're making about in the illustration, someone used the word building and didn't say building height. But if we're to follow the zoning ordinance and we're given specific rules of instruction, and I guess it's not splitting hairs to look at the actual words that they use, that's what we're supposed to do. But looking at section B, if we have a conflict or an ambiguity between what the text of an ordinance says and any sort of illustration given in the zoning ordinance, we're supposed to not pay attention to the illustration or the caption. All that matters for us is the text of the ordinance. So that may have been inartfully drafted by or written by somebody. It doesn't really matter. But for our purposes, all that we are supposed to focus on is what the actual zoning ordinance language says.
Right, and the text of it says that the term building height shall be the vertical distance, and it goes forward. So, but to say that when you write, any building shall not exceed 30 feet in height, and then you want to say that that doesn't fit building height as a definition, I don't think that's supportable. I really don't, because you have no other definition of height. You only have, you're saying, this says any building shall not exceed this in height. That's building height. And it only, when I look at all of the other plans and I see that that is how they were calculated, and my clients is the only one ever in front of the city of Troy that has been this way, I have to say, there's a reason why my client's being singled out here.
Well, just to follow up briefly, so if the word height is not defined in the zoning ordinance, the zoning ordinance tells us to just use the ordinary, I'll read it a second, what it specifically says. So this is again 2.01. Letter I, it says, terms not defined in this ordinance shall have the meaning customarily assigned to them. So I think once again, if the zoning board or if the city council determine we're not going to define the word height, we're going to give a specific definition to the word building height, but we're not going to give a definition to the word height, then all we can do is take the ordinary customary use of the understanding of the word height and apply it wherever it's found. Isn't that?
No, absolutely not, because your term says any building in height. You're not talking about the height of a fence. You're not talking about the height of a swimming pool ladder. You're not talking about the height of a shed. You're not talking about the height of my car. You're talking about any building shall be in height, and that is building height. Building height is the height of a building. And your section 5.063. Otherwise, if it's just height, then there's no basis whatsoever for your city administrator, your zoning administrator, to say it's from foundation to peak of roof. If I pull out a dictionary definition of the word height, it's not going to say from foundation to peak of roof. It's not going to say that whatsoever. You have a way to measure buildings in your city, and it's in the ordinance, and your city uses it for every building except the one owned by my client.
All right, any other questions for the applicant? All right, thank you, Ms. Victor. We appreciate it. Very helpful and illuminating.
Thank you so much.
Okay, let's move on to give an opportunity for the city administration to step forward. And please identify yourself for the record and for the board. We okay?
Yeah, sorry about that.
That's okay.
Good evening. Thank you, Mr. Chair, and the rest of the Zoning Board of Appeals for giving me an opportunity to present this evening. My name is Brent Savadant. I'm the Community Development Director for the City of Troy. I also wear the Planning Director hat. I oversee all development applications in the city, including preliminary site plan applications. I will be representing the former city manager, Mark Miller, who made that interpretation on April 9th, 2024. He retired at the end of May, and I didn't feel like asking him to drive down from Marquette to be here this evening, so that's why I'm here. Also with me this evening is Ben Carlisle from Carlisle Wortman Associates. The Carlisle Wortman Associates is the city's planning consultant, and Mr. Carlisle has been overseeing the preliminary site plan application review for this application, so he's very familiar with this application. He also assists the city in amending the zoning ordinance to assist the Planning Commission and City Council in adopting the provision that we're talking about this evening. So I'm going to make this presentation, but there may be times where Mr. Carlisle comes to the podium and answers a question that you may have. The packet that you were presented for this meeting included a PowerPoint presentation that I put together. I want to note that I did add, I believe, 4 slides. The reason I did that is I did see some of the correspondence that was provided to the city from the client's attorney on Monday We did not have an opportunity to perform a detailed review, but I did look at it enough from a cursory perspective to understand their salient argument, which is basically removing the gable solves the problem. And admittedly, the example I provided in the PowerPoint that you were provided with in the packet, I think it had the effect of inferring that that was the only elevation of the building that did not comply with the zoning ordinance. I've got some additional slides to show you that, based on our interpretation, there are multiple sides of multiple elevations of this building that do not comply with the provisions in Article 5. So I've got a brief PowerPoint presentation, Mr. Chair, that I'd like to present this evening. So as was indicated in the packet, the zoning administrator, the city manager on April 9th made a determination that the Westbrook site plan application did not comply with the height provisions in section 5.06, and the applicant is appealing this determination. It's a very focused issue that we're dealing with this evening. As the applicant's attorney referenced, there is a height definition in the zoning ordinance. This is the text portion of it. I'm not going to read it. This is the height definition illustration. I circled gable roof because that's the type of building that is being proposed for this site plan. Again, the definition that was presented this evening by the applicant's attorney informs the user of the zoning ordinance how to determine height for buildings, applied across the board for every gable roof, no question. However, May 24th, 2021, City Council amended Article 5 of the zoning ordinance. We've spoken about those, the applicant's attorney spoke about the provisions earlier. These provisions regulated maximum height and minimum setbacks in the NN neighborhood node zoning district. To give you some background, prior to the height amendment, there were issues related to height in the neighborhood node districts that were expressed by neighbors of projects in neighborhood node districts. So the intent of the amendment was to reduce the impact of building heights on abutting single-family residential neighborhoods. So section 5.06E3C, this is the provision. The part that's very important in this provision is C subsection I. Any building or portion of a building on a parcel abutting a one-family residentially zoned parcel shall not exceed 2.5 stories, 30 feet in height. To really drill down, or portion of a building. This is a very important part of this provision that we're going to focus on tonight. So, utilizing the elevations that were submitted as part of the preliminary site plan application, this is the example elevation we use to illustrate the point. This is a portion of the building. It's closest to and visible from single family. That elevation, that is the face of that building closest to the property, is outlined in red. It's sheet A10, building type A1. You see it again illustrated in red. It goes all the way to the top of the gable. When you measure this portion of the building, you start at grade, which is the lowest portion of the building, and you go to if you go to the crown of the gable, 33.5 feet. That exceeds the 30-foot maximum for any building on the site. A basic tenet of zoning is the particular shall control the general. It's one of the drivers for zoning ordinances throughout the country. This was codified in our zoning ordinance, section 2.01A. You see it circled. The particular shall control the general. So in this instance, the particular, which is regulations for height in NN when abutting single-family residential, shall control the general, which is height regulations applying to all buildings. There are approximately 30,000 parcels in the city of Troy, give or take. There are, I haven't counted, I'm going to be off by a couple, 50 parcels perhaps that are zone neighborhood node that are abutting single-family residential. This is very, very specific, very particular, therefore controlling the general. In the example that was cited earlier, the height of the portion of the building, 33.5 feet, exceeds the maximum. But again, I think there was an inference that that was the only elevation that this applied to. Let's look at another elevation. Sheet A10, right side elevation. I'm going to use my pointer here, so if you look at the screen. So peak of the roof, this is the grade immediately under the peak of the roof. If you measure here, it's 32 feet. By my math, that's more than 30 feet. That exceeds the height. If you go to the grade of this, the lowest part of this elevation, and you measure to the highest part, which is any portion of the building, that distance, you add another 3 feet. That's about 35 feet. If we calculate the height as per the definition, and we measure to the midpoint of the gable, we ignore the portion of the building above the midpoint. Another example, sheet A10 rear elevation. This is the portion of the building outlined in red, looking at it from grade to the peak of the roof. This portion of the building, if you measure again from grade to peak, is 35 feet. That exceeds the 30-foot height requirement. If you have two takeaways from this presentation, one, the particular shall control the general, and two, no portion of any building shall exceed 30 feet or 2.5 stories in height. I can answer any questions.
We'll start with Mr. Fox.
So in Mr. Miller's official decision, he does reference foundation as opposed to grade. And I appreciate that grade was referenced in the presentation because that does help with context. I guess I have a question and then a follow-up. First, would you mind commenting on foundation being used in the official decision, or?
Could you pull up the agenda and specifically Mr. Miller's memo?
Thank you.
Thank you. I think in this instance, foundations to me is the point where the foundation meets grade, and it's consistent with.
Sure.
It's interchangeably used with grade.
Well, and yes, I also, well, I agree with the interpretation that from grade or foundation, you know, the measurements measure how they do. I do think that maybe that might be a portion of the confusion in all of this, almost as if maybe it'd just be worth adding measured from grade or something like that to the end of the ordinance. That way there's just clarity in the later, in the particular, there's clarity on whether or not it's grade from foundation. Because reading this as an outside, you know, observer, not being involved in the process previously, that was one portion that tripped me up, was foundation versus grade. And I think that is something worth clarification. I digress.
Mr. Green.
Is this considered, would this be considered a series of residential structures? Were it to be built, or would this be commercial?
Well, if there, I would consider them residential.
Okay. I am not an expert, but from my cursory research, according to the Michigan Residential Code, at least as of a few years ago, what I'm finding is that the foundation is required to be above the grade, a minimum of 4 inches and often 6. Is that consistent with any information that you have?
What code are you referencing, the building code?
Yes, Michigan Residential Building Code. R404.1.6, height above finished grade.
Well, that's a separate code altogether, so I'm focusing on this application of the zoning ordinance, so.
Certainly. I was working towards the building expert, but my thinking there would have been, if foundation is always above grade, then foundation actually provides a cushion to the interpretation which would favor the petitioner as opposed to your interpretation. But even in that case, 32 feet wouldn't, minus 6 inches is still not 30 feet. Okay. Thank you.
Any other questions? Mr. Eisenbacher?
Yeah, in my study of this issue that's being brought before us, I went to the zoning ordinance and looked at two particular definitions. The definition of building height and then the definition of grade. Definition of grade on page 28 of the zoning ordinance says a ground elevation established for the purpose of regulating the number of stories and the height of the building. So it's talking about height and grade. The building grade shall be the level of the ground adjacent to the walls of the building if the finished grade is level. If the ground is not level, the average grade shall be applied. Were you looking at the average grade in these interpretations or the specific?
I was looking at the specific because it relates to that portion of the building.
Okay. The other thing I'm having a hard time seeing in this is if you change neighborhood node NN, but you don't change the definition of building height, how did it change? The zoning ordinance has a method of measuring a building height in the definitions of what words mean for this ordinance. And I'm having a hard time seeing how the definitions of those words are different for NN compared to the rest of the ordinance.
We hang our hat on the verbiage, any portion of a building. Now, remember, there were projects in the neighborhood node district that were very controversial with a lot of neighborhood opposition. Mm-hmm. So much neighborhood opposition, in fact, that the neighborhood node classification was a focus of our recent master plan update. When the city council adopted the amendment in 2021, it was to reduce the impact of the height and the massing on neighboring properties. So you have to, I look at it when I look at this provision, what are the neighbors going to be looking at? They're going to be looking at the entire portion of the building, from the lowest portion of the building visible to the highest portion of the building for that side of the building, for that portion of the building, for any portion of the building.
Okay. So if they built the building with a flat roof, there'd be no.
Yeah, I'm not an architect, and it's not my role to design, but it seems that there are some design steps that could be taken, including less manipulation of grade and flattening out the slope of the gable to the point of perhaps even considering a flat roof. There are options here for this design of this building to reduce the height of any portion and all portions of that building.
Okay. Obviously, the engineering is very different when you have a flat roof that won't shed snow and rain versus an angled roof that sheds precipitation.
Yeah, I did say reduce the pitch or flatten.
Okay. Okay. Thank you.
Okay, not seeing any,
I want,
Mr. Forrester.
Just, again, to understand here, your argument is you contend that the height that the builder's representative referred to doesn't apply here. The definition of height does not apply here. That's what your contention is.
That's my contention.
Okay.
The particular controls the general.
Yeah.
Mr. Green?
Do you know when the term building height, the definition, was added in a general way, as in prior to, at the same time as, or subsequent to the enacting or the modification to 5.06E3C?
That definition has been as is since at least 2011, and it may have carried over verbatim from the previous zoning ordinance without any changes to it.
Okay.
It may have.
Thank you.
No.
I was going to address a comment made by Mr. Eisenbacher with regards to one of the questions about our contention and it's important to remember the context under which this was drafted. So we started this, actually went back and looked, we started drafting this language in 2019, and it was in response to residential, multifamily residential buildings being constructed in the neighborhood nodes next to single family. This language was also coupled with another zoning ordinance amendment that talked about setbacks and green belts that were required. So in addition to what we thought regulating height, we also increased the setbacks for these types of developments adjacent to single family. So those were coupled together. And the purpose was to reduce the impact in the massing of these buildings on adjacent residential properties. To your question, Mr. Green, we did not look at the definition of building height when we made this change because we had written this and it went through our office, it went through the Planning Commission, it went through the Corporation Counsel's office, it went to the City Council, and I guess no one picked up on the potential confusion of the issue of this coupled with how we define building height. We felt it was clear enough when we say portion of a building meant any portion of a building, irregardless of how you measure or define building height. And the purpose was to really address the concerns brought in front of us where you have a manipulated grade or a changing grade where the front of the building may be 2 stories or 30 feet or less. The back side may be 35 feet in height. But if you measure grade based on how we measure building grade in the zoning ordinance, it may meet that definition, but the massing impact, the portion of the building that's adjacent to residential is much greater and higher than that's not. So the portion, this was written specifically to address issues of that, where there are issues with the grade changes where you may have portions of the building that meet the definition of building height, but greatly exceed the maximum height of 30 feet in the district. So the intent was to reduce this impact upon adjacent residential properties by ensuring that we measure it from any portion of a building, not just how it's measured by building height in the definition of the ordinance. So hopefully it clears the context of why this was written this way.
Mr. Fox?
This may be a silly question, but it wouldn't be my first one. So let's say that hypothetically you built a building like right to 30 feet, and then you put an HVAC unit on top of it. Would that HVAC unit going over 40 feet constitute a portion of the building? / would like the screening to hide it from
I don't think so because it's not,
Okay.
it's not a permanent fixture to the building.
Okay, okay. Just, yeah.
All right. Thank you to City Administration for presenting your side of the appeal. At this point, we will go to the public hearing. Can I get a quick show of hands? How many people are here from the public who wish to speak, just so I have a sense? I see one hand. Okay. I think what I might do is we'll do the public hearing, then maybe we'll take a quick break. We've been at it for almost an hour and a half. So what I'll do is I'll open up the public hearing, and anyone who wishes to come to the podium and identify yourself and tell us your relationship to the property, we'd be more than happy to hear from you.
think I can be quick tonight. I think half of my argument was already made. So I'm Mike Lipinski. Thank you for giving me the time to speak with you today. I reside on Carson Drive, which is the street directly behind this development. So I'm here as a resident of the community, but I'm also here representing the 92 members of the Woodlands of Troy Homeowners Association and the Board of Directors. I agree with a lot of the arguments that were said. I won't go through it. I was going to spend my time talking about the portion of the building piece as well. I think when Article 2 was rewritten, it was obviously rewritten to provide some guidance for developments to be more compatible with the surrounding single-family residential areas. I don't think it was ever intended to put a 35-foot structure on the property line, bordering the residential houses. So I think you have to, if you're going to be asked to interpret whether or not building height definition trumps the ordinance or vice versa, I think you can also interpret, what that compatibility means with that development as well. So I ask that you consider that the Planning Commission has actually made some suggestions as to what would be a more compatible use of this property. So they've looked at this quite a few times. There's been a number of developments that have come across, and the biggest thing here is, for the size of the property, the amount of units and the size of the units are really the issue. So, the height is something that we're very concerned about. So we're asking you to affirm the zoning administrator's ruling on that. I only wanted to make one other point. I heard enough or a lot tonight that there is no guidance or there's no rules anywhere that talk about building height. And although it's true from a definition standpoint, there is guidance in the master plan that does talk about transition and compatibility with these neighborhood nodes to the adjoining single-family residential. And there's actually drawings that show how you should ramp up in height from the single-family residential to, the heights that are allowed in these. So I think you can take some guidance from that in making these determinations as well. So I wanted to share that with you. Thank you for your time. I appreciate it today.
Thank you, sir. Appreciate it. Any other member of the public wish to come forward? No? I don't believe we have any written correspondence, do we, Mr. Eisenbacher? Or?
No.
No? Okay, so we will close the public hearing. And I guess I'll take the temperature of my colleagues. Would we like to have a short break?
Do we want to give the applicant and the staff time to prepare any type of rebuttal that they're planning?
Well, the next step would be offering both sides time for rebuttal. So I suppose they could take a few extra minutes if they wish to collect their thoughts as well. So why don't we? It's 8:23. Why don't we come back at 8:30? first offer the applicant an opportunity for rebuttal from what was previously said and public comment and so forth. Could someone help Ms. Victor with the mic?
I think I got this.
You got that?
Yes.
Okay.
Can y'all hear me?
Yes.
Okay. Thank you. I appreciate that you were given information about the history and responses of neighbors and so forth, but this isn't a determination of whether or not y'all like the plan or the amount of units or the size. That's for the Planning Commission at a later date. This is simply whether or not the zoning administrator correctly measured the property. And is it from foundation to peak of roof? So all of that doesn't relate to it. But I will tell you that when this was discussed at the City Council meeting on February 24th, 2021, what was said at that meeting was that, let me pull it up exactly so I say it right. What was said is that this was the intent of the amendment is to protect single-family residential property values by ensuring smooth transitions between multifamily and commercial development in single-family residential neighborhoods. It was not to put a more stringent requirement on multifamily or neighborhood nodes. Because if I'm building a single home, a single dwelling home, I'm going to build a home in your city on a residential property, it can be 30 feet in height, it can be 2.5 feet, and it is measured from the grade to the average, and I put a gable roof on it, it could be 35 feet, it could be 36 feet. As long as I am 30 feet, as long as it's 30 feet from the grade to the midpoint of the gable. So I can put on my property, a residential property, under your zoning ordinance, a single-family home that could be taller than 30 feet because I have a gable roof and it's measured the way it is. So what the city administrator, or the zoning administrator wants you to do is put a more stringent requirement, not a transition, not a compatible. They want you to do something that I could do as a residence. They want you to say you can't do it here. We have to have a different way, even though every other property in our city is measured according to Article 2 and the building height. For this property, we're going to measure it differently. And there's nothing in the ordinance that supports it. And it's not even supported by what y'all were saying in the legislative intent when the neighborhood no district was brought. Additionally, there have been other buildings that have been approved with gable roofs, measured the way that we're saying they should be measured. The Village of Troy PUD, and then K Troy No. 1 LLC, Center Court Project, and the Square Lake Court Townhouses. And I had limited time, but I looked up, and so the first one I went to, Square Lake Court Townhouses, is a neighborhood node. It's measured midpoint. It's not measured the way we're being measured. That was an excellent question about the HVAC, because that's the same thing as our decorative gable. If you're putting an HVAC unit on top of a building, you're not going to measure that, but you're going to measure a gable differently. There's nothing in the ordinance that would support that interpretation. It's kind of making it up as it goes along. In terms of, the ordinance says what it says. We believe it should be interpreted the way it says, and we believe it's a very narrow issue again here, that the zoning administrator's interpretation is incorrect, and that instead this building should be measured in accordance with Article 2. So thank you. As have every other building. Thanks.
All right, any follow-up questions for Ms. Victor? Mr. McCauley?
Actually, I have one for Mr., and I apologize if I pronounce it wrong, Mr. Straffa? Staffa? I have a question for him, if he is available.
Yes.
Yes. So you lived in Troy for how many years, sir?
For 20 years.
Fantastic. And you've built in Troy before?
Absolutely, so many houses.
And this is the first time you've run into something like this?
First time.
Okay.
It's a lot of first time that happened to me. I don't know why, but this is another first time.
Okay.
So,
all right, thank you. That's all I wanted to know.
thank you so much. Any other question?
I think we're good. Thank you very much.
This time I'll try not to hit anything on my way out.
Okay, thank you so much. All right, we will move on to rebuttal from,
There is another representative from that.
okay, if you are a representative of the appellant, you please come forward and identify yourself for the record, please.
Hello, good evening. My name is Arben Staffa, and I work for Tollbrook. And I just wanted to add another, there's another preliminary site plan that's being reviewed by the Planning Commission right now, which is on the south side of Waddles, east of John R. It's been submitted after the zoning ordinance text amendment 255, and it has a half basement and a flat roof, and it's not being measured from the foundation of the basement to the peak of the roof. It's being measured from the grade to the peak of the roof. Whereas here, we're being measured from the foundation to the peak of the roof. In terms of an example of another project that's currently under planning consideration, and throughout the Planning Commission meetings, I don't recall, there was some issues about the height in the beginning, but after the fact, there hasn't been any more discussion of the height because the planning department did say that it is compatible with the height. And I have the site plan application number as well if you guys need it.
Yeah, that's it. Thank you.
Thank you. No, sir, unless you're a representative of the applicant, no. Public comment is closed. Yep. Okay, we will move on to the city staff if they want to offer themselves a rebuttal.
As Arben Staffa, who just spoke, indicated, there is another project that's zoned neighborhood node abutting single-family residential, and the project does comply with this provision, so I don't understand the issue there. Sam Staffa indicated earlier this is the first time for this issue, and he's 100% correct, because this is the first time that they have submitted for a development in the neighborhood node that is on a parcel that abuts single-family residential. So and it was submitted after 2021 when the text amendment was adopted. The other examples cited by the applicant's attorneys were either different zoning districts. She mentioned the height of a single-family home. We're talking about neighborhood node zoning. Single-family homes are not permitted in neighborhood node. She mentioned a PUD. That's a different zoning district. PUDs are negotiated on a case-by-case basis. And she mentioned projects in neighborhood nodes that were reviewed and approved prior to this text amendment that limited the height that we're talking about. So the examples aren't relevant in this case. The particular controls the general. And I've taken up enough of your time this evening. Thank you very much.
If I may.
Mr. Eisenbacher?
Just for reference, what's the solution being used by the new applicant for that Waddles?
A flat roof.
It is a flat roof?
And pushing the building into the ground a little bit, but it still complies with the requirements for 30 feet and 2.5 stories. It still complies. It's a creative approach to complying with these provisions.
Okay, thank you.
Mr. Fox?
Yeah, to provide some level of context, because I've been in the Planning Commission conversations for that specific property. The other property being referenced is proposing garden-style apartments, which, are somewhat submerged, similar to what the applicant is referencing in this particular case. And none of measured from grade goes over the 30 feet.
All right. Thank you. Thank you, sir. All right, we have taken all of the testimony and public hearing. Now we'll bring it back to the board. Yeah, Mr. Fox.
May I just get some clarification from staff? I know the way that we word our motions is very important. What types of findings of fact or things do we want to make sure we're stating, whether we motion to affirm or overturn the decision from staff?
We provided proposed resolutions, something along those lines, but those are just general guidelines that could be supplemented by any particular facts that the board feels relevant. The ones we propose are very general, but it covers the basic of what you need to find.
All right. Anything else, Mr. Fox? Okay. Does any member of the board wish to be recognized for any discussion? Mr. McCauley.
I've looked into this quite extensively, having dealt with these types of developments in the past. And the things that stuck out to me in this, one is the language of our neighborhood node versus the general height of a building, that one's more specific than the other. That was pointed out by Mr. Savadan also, and it says, an important part brought up by you, Mr. Bosbeck, or portion, and is shall, which means it's mandatory. So if I look at the definition of that, then I kind of go, okay, where are they measuring from? Foundation? Where's foundation come in anywhere? I agree with the plaintiff, applicant, that the foundation isn't there. But when I asked her a specific question, not that she didn't have it, but I said, info regarding the grade to the height, she said it's just slightly higher. So in her own admission, she said that it was higher from grade. So from that standpoint, I look at it that we are looking at, like I say, the more precise versus the general on this. I look at the language to amend the height, that should be added, like Mr. Fox had mentioned, maybe to the ordinance to help clarify that a little bit. But otherwise, I feel like our zoning administrator and our planning commission, our planners have done what they're supposed to do. I think it looks good as far as that's concerned. I'm supporting our staff.
All right. Any other member of the board wish to comment or make a motion? Mr. Green?
I don't find that the applicant has made a compelling argument to support their claim that Mr. Miller, acting on behalf of the city, was erroneous in his interpretation. The applicant argued that the word foundation is used inappropriately as it's not used for any definitions of height in the zoning ordinance. But as per what I have discovered, per the Michigan Residential Code, and this is a quote, foundation shall extend above the finished grade at all points a minimum of 4 inches, which means that Mr. Miller's use of foundation is, if anything, favorable to the applicant, not harmful. And also per Mr. Sevidant's response to Mr. Fox, the terms foundation and grade are customarily understood to be largely interchangeable in instances where the height is being discussed, which is in agreement with Section 201I of our rules of interpretation. Therefore, I find Mr. Miller's use of the term to be in alignment with the zoning ordinance, not an erroneous interpretation. The applicant raised the rule of interpretation 2.01A, as did the city. The particular shall control the general. The particular shall control the general, as noted. The general is the previously provided broad definition of height. However, the very specific and also added later and therefore superseding, often in legal terms, I cannot say that exclusively, but commonly, addition of the 30-foot, 5.06.E.3.c I, note of any building or portion of a building on a parcel abutting a one-family residentially zoned parcel shall not exceed 2.5 stories, 30 feet in height. That's from May 24th, 2021, which was substantially after building height. Building height is not actually in question here. It wasn't part of Mr. Miller's interpretation. And so I don't see that as materially in question. What is in question is any building or portion of a building. And as Mr. Savadant showed repeatedly, from grade, somewhat interchangeable with foundation, per what I've noted, not per what he said specifically. The height exceeds consistently or frequently the 30-foot limit as set. And that is specific, so that would also supersede. The goal would be to try and bring those definitions together to try to make both ordinances or clauses work, and then when necessary to go with the one that would be more specific. This is more specific, any portion of a building. So to me, it's very clear that in this case, this is that Mr. Miller was in alignment with, in compliance with, and understood correctly the zoning ordinance and responded accordingly and provided a correct response to the applicant on that basis. I do not find merit in what they've said, so I will be voting to deny.
Mr. Fox?
May I ask what page of our packet the sample motions are on?
It's in the memorandum that was prepared by
I'm scrolling.
city attorneys.
They gave us different examples for different types of resolutions.
Thank you. I do also have one other question for staff. If the zoning board was interested in initiating a request to have staff clarify definitions in the ordinance, specifically like an ordinance amendment to say measured from grade or something to that extent, how would that process work? Would that be like initiated as another agenda item, or how does that hypothetically look?
I guess in theory, you could take it all the way from an extended conversation to an actual motion, clearly specifying exactly what the board is requesting.
Okay.
And you could ask the planning commission to look into that.
Okay. And then I would like to make a motion if possible.
I just want to Mr. McCauley's point, I think whatever motion we make, either for or against, we should take the general, no pun intended, of what's been talked about tonight, but take the general of what's been given to us, but also let's focus on specific facts or conclusions that we're going to base our motion on.
Yeah, of course. So I would like to make a motion, resolve that the April 9th, 2024 decision of the zoning administrator finding that the preliminary site plan for the Crooks Road development, the Westbrook, does not comply with section 5.06 E3CI on the basis that portions of the building exceed 30 feet in height is affirmed for reasons of, for me, it's the portions. Portions imply any part of the building, not necessarily just the building height.
Did you want to add the rest of the language there?
The Zoning Board of Appeals makes the following findings and conclusions based on the written materials, comments, and testimony of the applicant's representatives, other interested persons, professional consultants, and other factual material presented to the board to assist with deliberation. The applicant has not demonstrated the administrative decision was arbitrary or capricious, or that it was based on an erroneous finding of matter of fact, or that the decision constituted an abuse of discretion, or that the decision was based on erroneous interpretation of the zoning ordinance or the zoning laws. So, and yes, for me, it's on the word portions. Mr. Savinan said that's what staff was hanging their hat on, and I think that is a good justification.
Okay, we have a motion on the floor now. Do we have a second for that motion?
I second it.
Mr. McCauley seconded it. Any further discussion from members of the board that would like to? Yes, Mr. Green.
Purely for the record, you've already mentioned it, but I would like to restate also the interpretation 2.01B. In the case of any differences of meaning or implication between the text of this ordinance and any caption or illustration, the text shall control. As you said earlier, the text is what we're focusing on here. While the illustration was provided, it is clear to me from the text, as it is to Mr. Fox, that the word portion is what's in play, regardless of the gambrel, et cetera, as shown. And so the illustration is superseded or is immaterial.
All right, thank you.
Discussion.
All right, any other comments? Otherwise, we'll move to a vote.
Yes.
Mr. Eisenbacher.
I struggled with this quite a bit. Obviously, anytime an interpretation has come before this board, it ends up being likely to be litigated. If this 5.06E3CI, that's a crazy level of whatever definition of the part, but if it didn't say or portion of a building, I believe the petitioner's arguments would have full merit, where it would say any building on a parcel abutting a one-family residentially zoned parcel shall not exceed 2.5 stories, 30 feet in height. The normal interpretation of height would apply. That is the definition at the beginning of, along with all the other definitions at the beginning of the ordinance. But because it's a portion of a building, I believe that the portion of the building is anywhere from the grade to that height of the building in that portion. So I will be voting in favor of this resolution.
All right, thank you, Mr. Eisenbacher. Anyone else? Mr. Kinckery.
Well, I think the term or portion means that, to me, it means that any ridge on the roof has to individually meet the requirement of 30 feet. Whereas the building height term essentially says that we are going to come up with some kind of a fictitious number by looking at all the different ridges and the height of the ridge to the eaves, and then we are going to crunch all of that and then come up with this number, one number for the whole building. But by specifically including or portion of the building, it says that we are going to look at every individual ridge, and every one of those has to meet the physical height requirement of 30 feet. So I think that key phrase, by adding that, I think that's what it means. And so I plan to vote for the proposal.
Okay. I think we're ready to vote, Mr. Evans. So this is a motion to affirm the zoning administrator's decision and effectively to deny the application or the appeal.
Mr. Fox?
Yes.
Mr. Kinckery?
Yes.
Mr. Green?
Yes.
Mr. McCauley?
Yes.
Mr. Bossenbrook?
Yes.
Mr. Eisenbacher?
Yes.
Mr. Forster?
Yes.
All right, motion has been passed. Thank you for everyone's patience and your time tonight. We appreciate everyone's contribution and testimony. It was helpful to us, and we appreciate that. Have a good evening. We will now move on to our second item tonight, our second and last item under number 5, our variance request, or excuse me, 310 Burtman. So, Mr. Evans, when you are ready, if you could give us your presentation for 310 Burtman.
Thank you, Mr. Chair. And this is a variance request to allow a proposed detached accessory structure, a garage, to be set back 3 feet from the side property line, where the zoning ordinance requires the proposed garage to be set back 6 feet from the side property line. I've got a couple of exhibits on the overhead. This neighborhood is in a single-family residential area, north of 14 Mile and west of Stevenson Highway. The subject property on Burtman is outlined in red in the middle of this slide. I'll continue to zoom in so the board can get a concept of the neighborhood. Everything in yellow is zoned single-family residential, so this property and all the residential property in that neighborhood is zoned the same way. So the applicant has provided some elevations of the structure that they want to erect. And this is the site plan. The street Burtman is at the bottom of the site plan. And in the upper right-hand side is the proposed garage. And they're calling out right here a 3-foot setback from this side property line. The ordinance requires 6-foot setback. So they're requesting that relief from the board so they can proceed. And I'll turn it back over to the board for any questions.
All right, thank you, Mr. Evans. Any questions for city staff? Mr. Fox?
Am I right in seeing that the concrete between the existing patio and the proposed garage, there is a extension of concrete north of the bottom, north of the south border of the garage, that's 3 feet?
Right there?
Yes.
That's what it says, yeah.
Okay.
All right, any other questions? Not seeing any hands go up. Okay, thank you, Mr. Evans, for that presentation. At this point, if there's either the applicant or a representative would like to come forward and just please identify yourself for the record, and we would be happy to hear from you.
Paul Schiller, I work for Italy American Construction. I've been there for 26 years.
I'm not sure we can hear you, sir. Maybe you can pull the microphone a little. Okay.
Oh, was it not on? I'm Paul Schiller from Italy American Construction. We're the builder that's trying to build this garage. The lady that lives there, Dell, well, she's at 310 Berman. We submitted to do this and to move it over to 6 feet. The car would not be able to get inside this garage. As I did some research on this, if you take a look at I don't know what page that would be, that we were sent to planning on a detached, we were showing that R1E a lot has 7,500 square foot total lots. Hers is 6,000 square foot, so she has a non-conforming lot. So if I had to move this garage over 3 feet more, which is a total of 6 foot, to your rulings, she would not be able to get into the garage, or anybody. I got 19 feet or 20 feet to the back there, and average car is around 16 feet. Leaves me 4 foot to maneuver it to a 10-foot mouth. We call that a mouth.
Thank you. Any questions? We'll start with Mr. Fox, then we'll go to Mr. Eisenbacher.
So just to clarify, as you stated, this property is currently 15 feet or 1,500 square feet less than what is standard for R1E?
That's what
Did I understand you correctly? You said 4,500 and then this is...
7,500 square feet are what is on R1E2 lot size. Minimum is 7,500. So she has 6,000.
Okay.
So the depth of the house, or I mean the lot, is not allowing me to do what I need to do to get a car in there.
Okay.
So this would be...
Did you have a question, Mr. Eisenbacher?
Yes.
Okay.
I believe this neighborhood was platted well before the city ordinance, zoning ordinance was put in place. So your hardship would be the smallness of the property, just to make sure it's clarified.
That's correct.
Okay. And how many of were any of the neighbors spoken to? I believe we have one item in front of us. Did you speak to any of the neighbors, or did the applicant?
I have the homeowner. Okay. If you want to, she can talk. Or...
Okay. If we could call her up.
If she's willing to come up and...
Yeah, she's had an operation.
Oh, thank you.
Hi, Ellie Dello, and I own the property. I did speak to everybody in the area, and they said the same thing. We went around, I even talked to Paul about it. We went around in the neighborhood, and all the garages were 2 to 3 feet from the property line, because you can't get in, because they're so small.
Okay, that was my next question, is looking at the aerial views, and when I've bicycled and driven through the neighborhood, it looks like there's a lot of garages that already are in this exact same situation. Most likely, most of them were built at the time the houses were built or shortly thereafter. So you've got the negative time effect of zoning ordinance has been put in place. Okay. Thank you.
All right, thank you. Yes, Mr. Green?
It could just be a misunderstanding. It's a little a little difficult for me to see, and I didn't visit, so that's on me. But is there any particular reason that you chose to go with a detached garage as opposed to an attached one? And would going with an attached one permit reducing the 3 feet?
There's no space. Yeah, it's so small. If it even goes over 3 feet, it is the patio and the garage. So it was.
I have pictures if you want
Yeah.
to see what the condition.
Actually, I have pictures of what it looks like now because we did get a building permit. We did get a building permit, and they started the foundation and trenched it all out. And then they came to inspect it, to lay the cement, and that's when they found out that it was only 3 feet and not 6. So right now, I'm just a little flooded of trenches in the backyard.
Mr. McCauley?
Being very familiar with that area, family on Lyons, and I lived on Huntley. So I don't believe there's an attached garage in that whole area.
I think there's one on Sheffield, but it's like in
I'll
a
take your word for it,
cul-de-sac.
but it's not happening for the most part. It's
no.
the space. And most of them are basically fit exactly what you're looking at, and they are 3 feet, most of them from the property line. The only question I had was, if you could pull up that site plan that they had, that right there. My question is, I can't even see it. Hold on. The proposed concrete area that's extending to the lot line, why are we extending that to the lot line and not staying 3 feet off like the driveway and the rest of it is?
So that's a good point. As if we had showed you pictures, she has a carport.
Can you go closer to the microphone, just speak in the microphone?
Oh, I'm sorry. That's a good point, but the way her car, if it drove up the driveway straight in, we have an offset on the side there where the tracks of the garage door goes, and it's a 9-foot opening, so you need every bit to get in and then come back out to not hit the house. I mean, that's only 19 feet showing. Sorry.
That's what I was asking. Thank you, I appreciate that.
All right, thank you very much. I think we're out of questions. Yeah, you can just, grab a seat, and we're gonna open up the public hearing. I don't think, well, there's someone here who wants to speak to it, but I don't think there is anybody. But I think, as Mr. Eisenbacher referenced, we had one written correspondence to this.
Yes, we received an email that was printed and placed on the table from Mike Davey. He is at 325 Redwood, and he requests that the variance be approved.
All right, very good. Not seeing or being aware of any other public comment, we will close the public hearing and bring it back to the board for any discussion or any motions that would be, Mr. McCauley?
I'd like to make a motion unless other people need to make comments.
I don't see anybody else raising their hand, so go
All right,
ahead.
just checking before we go. At this point in time, I would like the variance request for, actually Paul Schiller for Italy American Construction for 310 Burtman be granted the variance for the following reasons. A, the exceptional characteristics of the property which are sought make compliance dimensional requirements substantially more difficult than the case of the majority of the properties. B, the characteristic must be related to the premise, which it is. The characteristic which is compliant with the dimensional requirements is not of personal nature. That goes with the property, along with the other properties in the area, so it'd be consistent. The characteristics which makes compliance with dimensional requirements difficult must have not been created by the homeowner previous. It was not. The proposed variance will not be harmful or alter the essential characteristics of the area in which the property is located, impair lighting and all the other stuff in our motion. So I'd like to make that motion.
Second.
All right, motion from Mr. McCauley to grant the variance, seconded by Mr. Fox. Unless there's any other discussion, I think we're prepared to vote. Mr. Evans?
Mr. Fox?
Yes.
Mr. Forster?
Yes.
Mr. Green?
Yes.
Mr. McCauley?
Yes.
Mr. Bossenbrook?
Yes.
Mr. Eisenbacher?
Yes.
Mr. Kenkre?
Yes.
All right, variance request has been granted. Thank you for coming out, and have a good evening. Appreciate your time tonight. That will bring us, let me grab my agenda. That will bring us to our next, next item, which is communications. Do we have any communications?
We do not.
Nope. Okay, so any miscellaneous business? I don't see anything listed.
So,
No, I think Mr. Fox might have.
Oh, Mr. Fox, go ahead.
well, so I guess I just wanted to get the temperature of my fellow ZBA members. Would we like to make a motion to have the planning commission look at clarifying that language that was of question tonight, as we discussed? Just, honestly, to me, it's just like 3 words, measured from grade. You know what I mean? Just slap that onto the end at 5.0 or 5063I or whatever the digits was.
Well, we can have it open for discussion. Mr. Eisenbacher, did you want to make a comment?
Yes. It's always been measured from grade from everything I've heard in the past for over 20 years. The thing that's different is we need to make sure that it's extremely clear that the normal height definition does not apply for this section. And I won't be surprised if this becomes a court case, in which case you don't want to make a change until after the court case, because that would hurt the city's position, obviously.
I see that.
Mr. McCauley.
Also, one of the things that we need to take into account is the word grade is not in there. And when Mr. Savanant talked about it, he talked visible part of the building facing the residential area. And that from the grade, because usually when you have a multi-level grade, you take the average. If they take the average, it'd still probably not be in compliant, but he's looking at the visible part of it. So if they're changing this, they need to put in there that visible part, not the average grade. So the grade from the visible side of the residence, something to that effect. So that way it's not taking the average, it's taking what's visible to the residents, because that's the concern. What are the residents seeing? And they're seeing this 35-foot high building from the grade facing them to the top of the structure, very top of the structure. So we got to be careful on what we can recommend them to go back and look at it and some points of emphasis for them to consider, but I would not make a motion to change it to anything, but more of a motion to have them review it and look at these possible scenarios and how it might help them better write that to clarify for us in the future if we get this.
I guess, yeah, I mean, I guess thinking out loud, I'm not sure I'm prepared to make a motion to amend. I mean, for my part, I thought we had to do a little bit of interpretation and understand the argument. But to me, the language wasn't that unclear once you start putting the pieces together, as explained by the zoning administrator. And I guess I would be cautious to suggest that we think that it's not clear, because as a board, we said it was clear, and then we affirmed the zoning administrator. So I would be, yeah, Mr. Evans.
Yeah, and also, your interpretation can be used by staff for future ones. Well, if someone else disagrees on a similar point, we can point to this and say, well, the board already affirmed that this applies. So this can be used in the future.
Well,
Okay, I think Mr. Green was next.
I would agree. I don't think we have anything to put forward. I had read the case over ahead of time and had thoughts, and whatever was presented to me this evening only continued to affirm what I had already been considering. I do think that maybe visible height as a phrase might be something worth looking at clarifying, and also your grade note for future. But as I say, I think it was broadly clear, and there was simply a legal attempt to get us to reconsider, which I don't feel was merited.
Yeah, Mr. Fox.
well, and to play devil's advocate with my own question, I know from the planning commission that, as we've said, we've had similar cases with garden-style apartments come in, and those developers found a way to work around it. They understood it. They were able to build within the what is defined in the ordinance. So I was posing the question more so just to get thoughts. I could see it not being worth discussing as well.
Okay. Appreciate it. Thank you for, it's a good discussion point. Any other miscellaneous business? Don't see anything. Don't see anyone coming forward to have public comment. So we will, we have cases up for July, Mr.
Yes.
Evans?
Yeah.
At least the one that we adjourned from last month, and then,
Yes, I think we have another one too.
okay.
Yeah.
So I guess we'll have a few cases next month, and so I will adjourn, and we'll see everybody in a month.
See.